The decision that just sent shockwaves through the country wasn't supposed to happen this fast. An 8-1 emergency ruling from the Supreme Court has upended everything Americans thought they understood about the Second Amendment. What began as a quiet legal dispute in one state has now exploded into a constitutional showdown that could permanently redefine the balance between individual rights and federal power. Tonight, we're breaking down exactly what happened, what it means for the future of gun ownership in America, and why one justice's lonely dissent may be the most important warning of our time. Before we dive in, make sure you're subscribed and have notifications on, because if you care about how your rights are interpreted, this is a fight you can't afford to miss. It started in the Heartland, a case most national outlets ignored when it first appeared on the docket. A small group of citizens challenged a newly expanded federal regulation on enhanced capacity firearms, arguing that it gave Washington more authority than the Constitution ever intended. At first, legal experts dismissed it as symbolic, but when the federal court fast-tracked the case and the appeals kept landing on the Supreme Court's desk, the nation realized this wasn't just another legal protest. It was a direct invitation for the justices to revisit the boundaries of the Second Amendment itself. By the time oral arguments reached Washington, D.C., every major advocacy group had taken sides. One camp warned that limiting the ruling would open the door to state defiance and legal chaos. The other said failing to act would erode the very principle of personal liberty the nation was built on. No one expected the court to move quickly. And then, in a single emergency session, it did. When the opinion was released, it wasn't a narrow technical ruling. It was an earthquake. 8 justices agreed that the federal government had exceeded its constitutional limits. Only one dissented. The majority opinion didn't merely overturn the contested regulation. It reinterpreted the standard for how any future restrictions on firearms could be judged. For decades, the guiding precedent was a careful balance. Courts could weigh public safety against individual rights. But in this ruling, the court declared that constitutional rights are not subject to balancing tests. That single sentence changed everything. Across the nation, analysts realized the implications. Every existing law that leaned on interest balancing, from background check mandates to magazine limits, could now face immediate challenge. In one paragraph, the court had dismantled decades of gradual compromise and replaced it with an absolute standard. If a right is written in the Constitution, it stands, unless the text itself provides a limitation. Hidden within the majority's reasoning was a reference few people caught, a 19th century case that reaffirmed the concept of dual sovereignty, the idea that the federal government and the states exist as separate guardians of liberty. The court quoted it directly: "The people, not the government, are the source of authority. The Constitution does not create their rights. It recognizes them." By invoking that precedent, the justices effectively reminded the nation that constitutional protections are not permissions granted by lawmakers. They are boundaries lawmakers cannot cross. It was more than legal philosophy. It was a reset button for the entire system of interpretation that had grown around the Second Amendment. Within hours, state legislators convened emergency sessions to review their own laws. Some cheered the ruling as a return to first principles. Others warned that it opened the door to fragmentation. A nation where 50 different interpretations of the same right could exist simultaneously. But one thing was clear: the era of deference to regulatory agencies was over. Justice Rowland, the lone dissenter, didn't disagree with the spirit of liberty. Her warning was about consequence. She wrote that the court's emergency action had invited uncertainty into a field where stability is essential. In plain language, she feared the decision would unleash a tidal wave of lawsuits, leaving lower courts drowning in conflicting interpretations. Rowland's dissent cited the post-Civil War chaos when states tried to reinterpret federal protections on their own terms. She compared the ruling to cutting the anchor before a storm. Still, the majority stood firm. Freedom, they argued, does not wait for bureaucracy to catch up. Whether you agree with her or not, her words instantly became part of the debate. Talk shows, op-eds, and legal podcasts dissected every sentence, trying to predict how far the majority intended their reasoning to reach. But the truth was, even the authors of the opinion couldn't control what would happen next. Within a week, Three federal courts cited the new decision to pause ongoing firearm-related prosecutions. Gun rights groups filed fresh petitions in Texas, Florida, and Arizona, arguing that local restrictions now violated the newly clarified constitutional standard. In Washington, legislators scrambled to understand what parts of existing law were still enforceable. The Department of Justice issued a carefully worded statement acknowledging the court's authority, but urging restraint in broad application translation. They knew this ruling could undo years of policy overnight. At the same time, governors from 12 states publicly announced that they were reviewing their firearm statutes for compliance with constitutional standards. Some hinted that they might go further, rolling back state-level restrictions preemptively before lawsuits forced their hand. For the first time in decades, the legal system wasn't simply debating the Second Amendment. It was recalibrating itself around it. What made this ruling so powerful wasn't just its outcome. It was the philosophy driving it. The majority's opinion leaned on what scholars call textual originalism, the belief that constitutional meaning is fixed at the time it was written. For years, critics argued that such rigidity ignores the realities of modern society. But the court countered, modernity does not amend the Constitution. Only the people can. That line struck a nerve. To supporters, it was poetic, a reaffirmation that rights are timeless, not trends. To opponents, it was dangerous, an invitation to freeze 21st century policy in an 18th century frame. Yet that's exactly why the ruling resonated so deeply. It wasn't just about guns. It was about how the nation interprets any right when technology, politics, and fear evolve faster than law. The political fallout was immediate. Within 48 hours, both parties called emergency strategy sessions. One side promised new legislation to restore responsible ballots. The other vowed to codify constitutional absolutism. Commentators on every network asked the same question. Has the Supreme Court just removed the last limits on the Second Amendment? In truth, the answer is more nuanced. The ruling didn't erase every law. It simply raised the bar for justification. Governments now have to prove that any restriction fits squarely within historical precedent. That's a much higher burden than before. Still, the optics were undeniable. Across the nation, supporters celebrated outside carousels waving flags that read, "The Constitution stands." Opponents warned of a judicial revolution that could make regulation nearly impossible. In the middle stood millions of Americans, gun owners and non-owners alike, wondering what this meant for their communities. Behind the scenes, constitutional scholars began analyzing the fine print. They noted that while the opinion appeared absolute, its phrasing left small openings, subtle hints that future cases might refine the boundaries. One footnote referenced historically consistent limits tied to lawful behavior, a phrase open to broad interpretation. That ambiguity may determine how far this decision actually goes. Law firms specializing in constitutional litigation immediately began drafting new challenges. At least a dozen test cases were filed within the first month, each hoping to become the next landmark precedent. Some targeted long-standing bans on certain accessories. Others questioned mandatory storage laws. Every one of them cited the same paragraph from the 8-1 ruling, the declaration that constitutional rights cannot be balanced away. For the judiciary, this meant years of work ahead. For citizens, it meant that the meaning of the Second Amendment was now once again up for debate in every courtroom in America. Beyond the legal and political noise, something deeper shifted. The public conversation about rights changed tone. For years, the debate centered on what the government allows. Now it shifted to what the government cannot forbid. Civic groups began holding town halls on constitutional interpretation. College students debated whether similar reasoning could apply to other amendments: free speech, privacy, digital surveillance. Suddenly, a ruling about firearms had reopened the larger question. Who decides where freedom begins and ends? That's why commentators across the spectrum called this decision the most consequential since Hilaire. It wasn't just another footnote in history, it was a philosophical turning point. Even as the ink dried, legal observers warned that the real battle hadn't even begun. Federal agencies would need months, maybe years, to rewrite guidance documents. Lower courts would struggle to apply the new standard consistently, and states would continue testing the edges, passing new laws to provoke fresh review. Some see that as chaos. Others see it as democracy working exactly as intended, tension between branches forcing clarity. But whatever your view, one fact is certain. The court has redrawn the map. Future litigants will now start from a new baseline, one that presumes liberty, not regulation, and that baseline will ripple outward, influencing not just gun rights, but how courts view every fundamental freedom. Because once the judiciary declares that no right can be balanced away, the same logic can echo across the Bill of Rights from speech to privacy to religion. So, what happens now? Already lawmakers are drafting bills to test the new standard, some to push its limits, others to define them. Legal think tanks are preparing historical analyses to defend upcoming challenges, and the Supreme Court itself may soon face another round of emergency petitions asking it to clarify what its own ruling means. The truth is, no one knows exactly how far this will go, but every constitutional era begins with a moment like this, a single ruling that forces the nation to reconsider who holds power, the government or the governed. As one commentator put it, this wasn't just a decision about guns, it was a decision about the Constitution's backbone. Whether you see this as restoration or regression depends on your faith in freedom and your trust in those who interpret it. The Supreme Court's 8-1 emergency decision didn't end the fight over the Second Amendment. It restarted it on new terms. From this point forward, every courtroom argument, every legislative proposal, and every public debate will trace back to this moment. The day the highest court in the land reminded the nation that rights written in ink cannot be erased by interpretation. If you believe this conversation matters, make sure you're subscribed and share this video, because no matter which side of the debate you're on, one truth remains. Your rights will only stand as long as you understand them and defend